Evening, everybody. It's 7 o'clock right on the dot, and knowing how efficient our managing and our disciplined people are, I figured we'd start this one very, very promptly. My name is Matt Greenwood. I'm the manager for membership services at the Ontario Soccer Association. I'm really pleased to have Michael Smith from our Discipline and Appeals Committee, one of our OSA instructors, to deliver this session for us. This is our 5th webinar from the Membership Services Department, and a really great way for us to get education out there to the grassroots and to the district associations without the time-consuming process of having to book a room and a meeting and getting everybody together in one venue. We're also recording these sessions so that they're all posted at a later date on the OSA website for future reference. So if you need them within your club or district in the future, they can be used as a point of reference. If you have any questions this evening, you'll have a chat window and a questions window on the right-hand side there. If you have any, just put them in there and point them in my direction to the Ontario Soccer staff person, which will be me, and we'll either answer them offline or we'll bring them to Michael's attention as we go through the workshop to respond to. Okay, so without any further ado, I will hand over to Michael Smith, who can take us through the presentation. Enjoy the next 45 minutes.
Thank you, Matt. I'm just loading the presentation. Can you see it?
Yep, that looks great, Michael.
Okay. Good. All right. Well, first of all, thanks very much, everyone, for joining us. As Matt said, this is a presentation to go through some of the discipline policies that affect all of us, not just the folks that run the hearings, but also those people that come in as advisors or accused or representing their clubs. The approach we're going to take tonight, as you can see there, is we'll talk our way through the reports and the process, talk a bit about the two types of discipline, and at the end we'll touch on issues that relate to best practice and where you can get other resources. Most of the reports that discipline people receive do come from match officials. We do receive material from other folks, but match officials would be the majority of reports most of us receive. So our seminar this evening will focus on how the process works when we receive match official reports. You can use this as a mirror for most of the other types of reports that might be received, which we will touch on shortly. Basically, everything begins with a report. We have a match official game report. We have a match official special incident report. A special incident report would touch on issues that may not be directly game related. It may be an incident that occurred near the end of the game at the bench. It may be an issue with spectators. It may be an issue involving team staff. It's a variety of things, basically. The third type of report we would receive is a written complaint from another registrant. Almost always those would be opposing team staff or from another club or an organisation. We do also occasionally get complaints that come from a third party. Typically they would be spectators at a game. Often they're parents that wish to record their concern about what happened in the game, something they saw on the touchline, concerns about the game official. But those are basically the main reports we receive. Now, how does the time frame for this work? Well, first of all, the OSA policies require a report to be submitted within 60 days of an incident taking place. Usually these reports do actually get written and submitted well before that time, but under the policies a person would have up to 60 days to submit a report. Now let's just touch on how that would affect game officials. Most game officials will submit their reports much sooner than that, but you can get circumstances where a third party might dwell on something for a week or so before they finally make a decision to submit a report. Once that report has been received at the governing authority, they have 30 days to take action. Let's be clear what we mean by action. It does not mean that a hearing must take place within that 30-day time frame. All that's required under the policy is that the governing authority begin the process, and usually you would expect that a hearing would take place within that 30 days, but that is not a requirement. You certainly would have circumstances where an incident or a report may be complex enough that you would have to consider other issues, which we're going to touch on now. The game reports usually get submitted within 2 to 7 days after a game. Here's a basic fact of football. Laws of the game. And for those of you interested in arcane facts, the referee on this year's Laws of the Game is a Dutch game official called Kuipers. Law 5 in the Laws of the Game states that the referee is the final authority on matters that relate to the game they officiate. That applies at all levels of the game, so that applies right down to mini games with children 7, 8, 9 years old with a 14 or 15-year-old game official. Because the game official is the final authority, this means that their reports are official documents. What that means is they don't need to appear at most hearings. Now, we've described it here as run-of-the-mill hearings. A run-of-the-mill hearing would be a hearing involving, let's say, violent conducts, foul and abusive language and gestures of the game official. The report on its own can stand for the referee, and the discipline panel would consider that as an official document. It's important to keep that in mind. Submitting a report. As we noted, most of the time the reports from a match official will arrive in the office between 2 and 7 days. Typically, they may get there in about 5 days. The league receives the report and reviews the contents to determine how the discipline process will proceed. So, what does that actually mean? The first decision that might be taken is based on the report they've read, is an investigation necessary? Now, if an investigation is necessary, this would involve someone appointed by the discipline chair to look into the report, if necessary, to speak to those people who may have been at the incident to determine what other information might be necessary. It's important to keep in mind that if an investigation takes place, then the person that does the investigation cannot then sit on any discipline panel that may come out of the investigation. Once they've done their investigation, they are off on the sidelines. The next decision that would be looked at is which misconduct charges would fit the incident described in the report. You've got all kinds of different considerations there. So here's a sample here from the Misconduct Table. This is relates solely to a small section of the tables that outline the different misconducts. There are misconduct tables for players, team officials, match officials, clubs, districts. Each one has its own set of misconducts. There are obviously, of course, with the players and the team officials in particular, there are parallel misconducts. But just take a look at one or two of these because it will help to understand what happens later on. If you looked at 119, dismissed for serious foul play, you'll see a first seasonal offence for that is a 2-game suspension. That's a clear cut. That's the suspension that a discipline panel would have to mete out if they felt the accused person was guilty. Then look at the one immediately underneath it, 119A, dismissed for serious foul play, where there was an obvious attempt to injure. You look at that, that's a 4 to 8 game suspension. Well, that become relevant later on in the things we talk about, but just take a look down, you'll see match official assault, first lifetime offence, 6 to 12 month suspension and a $200 fine. In addition to that, of course, the club would also get fined. You'll note that the most serious of charges, the game official charges, they're lifetime offences. So what that means is, in practice, if someone is found guilty of a match official assault, that stays on their registration record in the book or card during the time that they continue to play or coach. So the previous table outlines the different types of misconducts and the types of suspensions. That brings us to this. The charges themselves would determine how the process proceeds. You have discipline by hearing and you have discipline by review. So, what determines when a hearing must be held? Firstly, any charge where there's a range of suspension, as the one is shown there, you must have a hearing for that. Any charge where there's a fine of $200 or more, you must have a hearing for that. Any charge where the suspension is 1 year or longer. And you'll note there that in those cases, the match official is also required to attend. This is a policy requirement. It's a very long suspension. The accused person clearly wants the opportunity to present the best case he can to avoid such a suspension, and the referee is required to come along and essentially present his case for what happened during the game. Finally, a discipline panel can choose to hold a hearing where they choose to do so. That becomes relevant with some discipline by review cases, and where the accused has requested a hearing. So we're going to come to that immediately anyway, so let's just go to that. Discipline by review. This is the fundamental measure for discipline by review. Where there is a specific suspension, you can do the case by review. So, for example, I've picked out 3. You can see there each one of those are very specific misconducts which carry with them specific suspensions. So in the event that the accused does not ask for a hearing, then this is how a league would typically deal with cases of this sort. The review panel must meet at least once a month. In practice, what actually happens is most DPR panels will meet weekly or bi-weekly. Well, that depends on the volume of work. But if you took the larger leagues, the Central Girls Soccer League or the Central Soccer League, they certainly would be meeting weekly or bi-weekly. They get quite a lot of work. Requesting a hearing. As we've noted, most leagues will use discipline by review for as much as possible. An accused can ask for a hearing within 3 days of their incident. So if they get sent off on a Monday, they have until the end of day Thursday to ask for a hearing in order basically to present their own defence. Because of that, governing bodies do need to allow enough time for the individuals to request a hearing. Facts. Facts really are the sole basis of what the hearing is about. It begins with the game official's report, but the hearing itself is also intended to establish agreed facts about an incident. It allows an accused person to present their side of an incident and present information they think will help their defence. Look at the last part. It can be important. There's no point in having a hearing if all the panel is going to do is rubber stamp every report that comes in. The whole purpose of the hearing and the many policies that go into supporting that are to give the accused person an opportunity to state their case, and the panel can then consider whether or not there might be mitigating facts that could affect how they view the incident. In particular, this might allow them to reduce the charge when they're looking at the case. Let's talk very briefly about that. Often an accused person receives a hearing notice and sees charges which seem quite harsh given the incident as they recall it. Usually that's because a discipline panel, when they're in a hearing, they cannot, based on the evidence, decide to charge somebody with a more serious charge while the hearing is taking place. In the event that they had a hearing and concluded that the accused should be charged with something more serious, effectively what happens is the panel must then end the hearing, recharge the accused with the more serious charge, and arrange a new hearing. And that is why most discipline panels will likely use the more serious charge when they are informing an accused of what they're being charged with. For example, you have 2 examples of violent conduct. Violent conduct and violent conduct where, in the opinion of the panel, there's an intent to injure. Clearly, the intent to injure is a more serious charge. Most panels will probably use that charge, and then in the hearing they can drop it down to the lesser charge. The lesser charge is 3 games, and the more serious one is higher in a range, begins at 6 games. What are the basic responsibilities we're trying to deal with when we run a hearing? Well, first of all, attendance. A discipline panel comprises 3 members. You have a discipline chair, you have a recording secretary, and you have a 3rd member. Now, occasionally, there may be circumstances where one of the panel members is not able to make the hearing, even though everyone is expected to be there. The accused can sign a waiver to allow the hearing to proceed without 3 panel members. You don't have to do this if you're the accused, but if you wish to go ahead with the hearing on the evening, the discipline chair can ask you to sign a waiver, and then the hearing would proceed. The accused must be present. Look at the second part of that. Unless the panel has a signed proxy from the accused. Now often, especially with adult players, they may work in the evening, and typically that's when discipline hearings take place. They're working, they can't make it. The coach is willing to come along and represent the accused person. The panel can only hear that case if the accused person provides a written proxy to his representative, clearly stating, I can't come, but this person can represent me. No panel should proceed with a hearing where the accused is not present without having a proxy. If you do so, then you immediately open yourself to grounds for an appeal if the accused decides that he doesn't like the result. The match official does not have to be present, we noted that earlier, unless the match official is charging the accused with assault. In that event, since that's the most serious of charges that can be brought, the match official must be at the hearing for that. The other circumstance where the match official would be required to attend is if the discipline chair required their attendance. When would that happen? That might happen in circumstances where the match official report perhaps is not so clear as it should be, or the incident written up is sufficiently serious that the panel would also like the opportunity to question the game official in more detail about what actually occurred in the incident. I'll give you an immediate example, a large-scale brawl at the end of a game, for example. The match official might write it up in practice. If that's all that happened was a brawl at the end of the game, he doesn't necessarily have to show up for the hearing. But I think a sensible discipline chair would ask the game official and possibly his assistants, his or her assistants, to come to the hearing and answer other questions the panel might have. We've already noted that most of the time it's the match official's reports that come through the system. But where the complainant is not the match official, for example, a member of the team staff, a spectator or a parent, if they write a complaint that leads to a hearing, then that complainant must show up at the hearing to present their complaint in person. Reason for that's really quite simple. It allows the accused person the opportunity to answer his accuser and ask questions of the person bringing the complaint in order to help their defense. If you're a coach and you have one of your youth players ejected from a game, and you go to a hearing. This is a policy. Every youth player in a hearing must have an adult advisor. And when I say in a hearing, I mean an accused in the hearing. Any young player that shows up at a hearing without an advisor, the hearing would not proceed. I think most clubs know that, but for those listening, it's always wise to plan ahead for that. And one particular piece of advice I think I would offer is, I mentioned the coach being the advisor. That's often not the best solution, because the coach may actually prove to be a witness as well. So the folks involved will need to discuss whether or not somebody else should take on the role of advisor to the accused person. The reason for that is simple. The policies state categorically, if you're the advisor, you cannot be a witness. It's as simple as that. So that's something that, again, many discipline chairs do actually clarify that with the folks when they come to a hearing, especially where the advisor is the team coach. Quite a few cases require the club rep to be in attendance. In most serious cases, the club rep is required to attend. They're also required to attend in circumstances where the discipline chair asks them to come. The accused obviously can bring witnesses. Be surprised sometimes that folks show up for the hearing and they don't bring witnesses and sit there and say, oh, I could bring a witness? You can bring witnesses. Finally, with youth players, you very often find that a parent will come as an observer. In fact, the policies actually state that those people required to attend a hearing can have 2 observers each. In practice, that doesn't happen very often, but you certainly do find that a parent will come as an observer. We mention it here partly to underline for you that it is actually best if the parent remain as an observer rather than, for example, a witness. They tend sometimes to get perhaps too involved in the process taking place for their child. There are lots of policies in place to protect the interests of that youth player. When a parent comes to my hearings, I'm very happy to have them. We give them a chair, they sit in a corner against the wall, and they listen. What actually happens in the hearing? Well, first of all, everybody comes into the room. That means the accused, the advisor, and any witnesses. And then the report's read, and the accused is told what charges they face. This is important. The witnesses then leave the room until they are called back in. Then the panel ask the accused to tell their side of things, and essentially we ask them to talk to us about the incident from their point of view. We then ask them questions, and these questions are intended to clarify what the accused person said, and often to match that with, for example, what the match official report may have described. You'll often find circumstances where the accused person describes an incident which doesn't actually match up to what's written in the report. So therein is the task for determining what would be satisfy the panel as to facts of what happened. The accused can bring in witnesses individually. They don't come in as a group, they come in one at a time, and they're invited to tell the panel what they saw or heard about the incident. Then the panel asks them questions. But let me draw your attention again to this. Saw or heard. No panel is interested in hearsay. So, for example, you will often find a witness comes into a hearing and says, no, I wasn't there, but I was told. Well, that's no good. You can't ask somebody not in the room to clarify what they saw or heard if they didn't see it. So anytime you're going to bring witnesses, make sure they actually saw or heard the incident they're going to talk about. The policies state that there are no limit to witnesses. The panel can limit the number of witnesses if the evidence becomes repetitious. Let's talk very briefly about that. No disciplined panel should turn away witnesses without first discussing with the accused person whether or not, let's say they've had 3 witnesses come in, the basic story has unfolded, all 3 witnesses are now saying quite similar things about what happened. We have a 4th witness come in, we hear similar things. Now the panel will ask the accused, is there anybody else outside that may have something new that we haven't yet heard? And that will be the basis on which the panel would determine whether or not they would then say we've heard enough from the witnesses. What are the responsibilities for team officials in situations like this? Well, first of all, if you do have a player ejected from a game, it's up to the league or the governing body to notify your team and your player of any suspensions to occur. Usually, if that's through a review process, the review process may not occur for a week to 10 days after the incident, keep in mind. You're not expected to do anything regarding the incident until you hear from the league or the governing body, note the last part, unless you are requesting a hearing. So what that means is you can play the ejected player in the next game unless the league advise you otherwise. And don't forget, if you are going to request a hearing, you have 3 days from the time the incident occurred. So in the illustration we gave right at the start there, if your player got ejected on a Monday, you've got to the end of day Thursday to submit a written request. One other point on that, you will sometimes be required to, you'll be required to pay a hearing fee. All leagues will ask you for a fee. The OSA policies are quite clear on how the leagues and governing authorities operate. They prefer that a list of scheduled hearing and review dates is posted on their website. This really is now almost the standard across all districts and all leagues. If you go to most of the leagues' websites, they will all show a list of hearing dates or review dates. The bullet point there, if there's no schedule, then an accused person is entitled to 15 days notice of a hearing, and along with the notice of a hearing, of course, is details of the charges, and an organised panel or an organised governing organisation would also include the related reports that called for the hearing. You can ask for the match officials report if you have not been sent it. And just so we're clear on that, the policy states that if you request in writing the match official report, the governing organisation has 48 hours to provide it to you. That's always a sensible thing to ask for, in particular in circumstances where the incident may be serious or the charges themselves are serious. It gives the accused a chance to ask for witnesses to come forward and arrange time to show up for that hearing. Best practices. Well, first of all, I'll stick for the moment to the leagues and districts. All leagues and districts keep track of the discipline process. They typically do that using Excel sheets. They have coded case numbers. Some leagues and districts will actually run a database, not a spreadsheet, but a database. It's essential in a properly run league or a district that you know what's happening with the discipline process. That way, when you need to, you can report information to the next governing organisation. So, for example, with a club or a district that's running a tournament, when they run a tournament, if it's a club, at the end of the tournament, they have to submit to their district, which is their governing organisation, they have to submit to their district a record of the discipline that took place during the hearing. Why do they have to do that? Well, very often incidents take place on the last day of the tournament. Players get ejected, coaches get ejected. They're still subject to discipline. And in circumstances where an incident cannot be heard at the tournament, the governing district sends the reports down to the district where the accused or ejected players or coaches are registered, and they ask that district to run a discipline hearing on the incident. We're near the end. Checklists. If you go onto the OSA's website, there's a lot of material on there that relates to the discipline process and the appeal process. And our discipline coordinators on the staff at the OSA are terrifically well organised and very well informed, and they'll be delighted to help you if you need help with things like checklists, scripts, or responsibilities that relate to running a panel, or even the responsibilities that might relate to having to appear at a panel. This is where you're going to find all the information on this evening's seminar. Section 12 is the entire discipline policies and procedures. Section 13 is the appeals, and 14 relates to protests. Very briefly, since I imagine we've got a little bit of time, the timeframes for some of this. With a discipline hearing, a discipline panel has 15 days in which to return their decision in writing. When that's sent to the accused person, that decision is also accompanied by the accused's rights of appeal. Now, the rights of appeal allow the affected parties to appeal the decision made to the next level of governing organisations. So, for example, if you are involved with a regional league, the Central Soccer League, the Central Girls Soccer League, the Eastern Region League, these are regional leagues that decisions from their discipline panels are appealed to the OSA. Appeals to club decisions would go to that club's governing district. Earlier we mentioned match official assault. We briefly touched on the requirement for the match official to be at the hearing for that. Match official assault is one of 3 serious charges that are considered OSA mandated hearings. And what happens with those is it's an OSA case where the case is heard by the district panel where the accused is registered. And that district panel is representing the OSA. So why is that important? Well, that's important because the decisions from a match official assault case is an OSA decision, which means any appeal will go to the Canadian Soccer Association. Okay, I think that probably covers things. I'm not sure if there are any questions, but Matt, if you're there, is there anything we can add?
Excellent, thank you, Michael. Yes, that was great. That was great. Well, a lot of information there, and certainly aside being a very well-behaved soccer player, a side that I don't get to see too often, which is nice. A couple of questions have come up though. Yes. Ilya has asked, what if there are 2 charges accumulating to 6 games, but separately the charges are 3 games plus 3 games? Is it DBR or DBH? Or does that not even come into play?
I'm just thinking about that. Give me that question again.
What if there are 2 charges accumulating to 6 games, but separately the charges are 3 games plus 3 games?
I would have a hearing.
Okay.
Partly because you're now you're looking at, even though the 2 separate charges may be specific suspensions of 3 games each, you're now running into a fairly long suspension. If you think about it, if it's a youth player, that's a 6-game suspension. That's virtually 1/2 of their playing season. And I think that in circumstances like that, you probably would want to have a hearing in order to at least allow that person to present some defence to it, or at least to comment on it. The policies themselves may indicate 2 separate misconducts, but they, if you're going to run them together so that you give somebody 6 games, I would say you should do a hearing.
Okay, good, thank you. Actually, we've got a couple more questions as well here. You're popular tonight. So,
yeah, maybe. That's rare for a disciplined person to be popular.
True. Maybe in business, not in personal life. So if an accused, Tim Jansen has asked, if accused confirms to attend but doesn't, can the panel suspend the accused, or can they suspend them until they do show for their hearing?
Yes, if an accused person does not show up for a hearing, they are suspended until they come to a hearing. So that actually means they, at that point, they certainly can't be playing games. What needs to happen is that the if the hearing is scheduled for, well, let's say the hearing is scheduled for this evening, and the accused person does not show up, then tomorrow the league office or the administrator of the governing organisation is going to send out a note to the person that didn't show up and their club, informing them that they are suspended until they come into a hearing. And the way the process works for that, essentially now the ball is in the no-shows court. They now have to write in and request a hearing, and they have to provide a request for hearing fee. I'm not sure whether each league or district has the same fees, but certainly you could be looking at a request for hearing fee that would be anywhere from $50 to $100. That's the policy. You will find that many districts will waive the fee, or at least some will. I think it depends on the circumstances as well of why the accused person didn't show up. But basically, that's the process. They don't show up, then you suspend them. But you also must make sure that you inform them of that immediately. And the reason for that is we have had appeal cases at the provincial level where somebody is not aware that they've been suspended and plays in a game, and then is charged with playing while suspended, which starts to, in terms of suspensions or fines, if you're an adult player, that can start to add up. So you really do need to make sure that you notify them. As long as you notify them that they're suspended until they come to a hearing, you're good.
Very good. Excellent. Okay, thank you. The next question from Steve De Silva. Can the panel object to recording the hearing, and is there a maximum number of panel members?
Okay, when you talk about recording, I'm assuming initially, well, let's talk about that. You've got two options. You can't refuse an audio recording. If somebody wants to record, just do a voice recording of the hearing. I've been in hearings where folks want to do that. I simply tell everybody present that it's going to be recorded and leave it at that. I've not actually had anybody object to a recording. As to the specific question, can you refuse? I think certainly it would be within the it's within the purview of the chair to decide that. But I think if you look at the policies do state that it could be recorded. If you're looking at video, well, now that's a different thing. Let's begin perhaps with my own personal view on that. My personal view of that is that when somebody comes in and they want to take a video recording, what's in play there in part is a process of intimidation. You don't really find that very often. I think I could count on one hand the number of people that have come in and asked if they could do that. I would not allow that, and the reason I would not allow that is if you have witnesses, typically this would only occur with a more serious case. So you've got witnesses coming in. Those witnesses don't have to sit there. They're nervous enough without having to cope with the fact that one of the accused party, which is usually who it is videoing the process. So specifically, if that answers that question, does that answer it for him?
It does, yes. And then the maximum number of panel members. I know you mentioned 3 listeners there.
Well, yes, the maximum number of panel members. That's a tricky question. I don't think the policies actually state that you can have more than 3. But certainly you don't want less than 3 in most circumstances. And the reason you don't want less than 3, ideally, is the chair would not be the first person to provide their opinion. A good chair is going to invite the other 2 panel members to give their impression of what they heard and whether or not they think the accused person might be guilty. The chair would be there to, in the event, let's say, that the other 2 panel members disagree with each other and one thinks the guy is guilty and one thinks he's not guilty, then the chair would mediate that and or make a decision based on, well, I think he's guilty or not guilty as well. You don't want, if you raise the number of panel members, it gets complicated. It's a good question, actually. I don't think the policies say you can't have more than 3, but I certainly wouldn't have more than 3.
Great, great. Okay, we've got a few more questions. You're getting popular tonight, Mike.
Yeah, well.
Elia's come back again with another. So when the decision is sent out to the accused, which involves a month suspension, when does it start? Since the accused has the right to appeal within 14 days. Does it start after the 14 days of the decision or immediately upon notification?
Well, it depends on the case. If it's a month, then clearly it's not a match official assault. So it would, in theory, begin from the point the hearing took place. It wouldn't begin following the appeal period. The suspension, you suspend somebody, you send out the notice of decision with that appeal notice, with the rights of appeal, and they are essentially suspended while they decide or while they go through the appeal process.
Right. Okay. Okay.
So yeah, maybe just if I could just add one last thing to that. In the event, for example, that and this in particular would be the case with a club. Typically, most player misconducts don't carry fines. There are some, and certainly any adult player can be fined, or any player registered to an adult team can be fined. But the bulk of fines for discipline processes usually go to clubs. And in the event that, and again, if they're fines, they tend to be larger ones. They tend to be carrying with them more serious cases. That fine has to be paid to the governing organisation before an appeal would be considered. So, for example, if a club got fined $1,000, they would have to pay that $1,000 fine and then submit the appeal. If they submit an appeal and they've not paid that $1,000 fine, then their appeal will not be entertained.
Right. Okay. Good information. Okay, we'll take a couple more because I know we're getting close to our deadline. If we don't get to any of them, we'll follow up within the office over the next day or so. Steve De Silva's also asked, can an advisor speak at a hearing?
Yes, the purpose of the advisor is to assist the accused person. I don't think the panel want to be too rigid with the advisor, providing the advisor is not suddenly acting as a witness. But certainly the advisor can ask questions of witnesses that come in, for example. You'll often find that's the case with younger people who perhaps are a bit nervous. They might be looking at a serious suspension. Let's say they're part of a group of young players who were involved in a brawl. I mean, it does happen. For those of you wanting the definition of a brawl, the OSA policy states a brawl involves 3 people or more. Well, typically, most brawls involve quite a few more players than that. But now that's getting serious. You're looking at violent conduct, you're looking at involvement in a brawl, you're looking at possibly involvement in a game being abandoned. As witnesses come in, that youth player may be a little nervous. Certainly, in my experience, they are often intimidated by the process. They've never been in a hearing before, and in fact, quite a few coaches have never been in a hearing before. So you do want the advisor to be able to ask questions on behalf of the accused. Typically, all questions go through the chair. A very, very small anecdote. I did a hearing a number of years ago where the accused person, one of the grounds that he appealed the panel's decision was that he was quite combative in the hearing, and I made it clear to him that any questions he had of the witnesses had to come through me. So effectively, he asks the question, he's looking at me, and the witness is answering. And he used as a ground for an appeal the fact that I made him speak to me with the question rather than him asking the witness direct. But if you look at the policies on this are crystal clear. All questions go through the discipline chair, and the reason for that is to keep things at a, if you like, a less combative environment. You often find if you've got an accused questioning the witness direct, you end up in an argument. We don't want that.
So just on that with the advisor, Debbie Wright's asked, and we'll take this as the final question for tonight, what is the maximum age for a youth player in relation to them being able to bring an advisor?
18 and under. So up to 18, you consider them youth.
Okay. Yep.
Okay. After that, they're considered adult players.
Okay. Okay. Good. All right. I've got 2 or 3 more questions, but
yeah, sure, that's fine. Okay, that's fine.
Okay. Let's see if we can squeeze them in then. So let's see. Lauren Babala, what are circumstances in which a hearing reschedule would need to be accepted or rejected?
Well, that would depend on the context. Are we talking here about an accused person that doesn't show up? If the accused person doesn't show up, then we've already dealt with that. They get set aside. They're in limbo until they come to a hearing. You could have a circumstance where a hearing begins, and during the course of the hearing, the accused person points out that their crucial witness is not there. And in circumstances like that, first of all, I'm going to ask that accused person to tell me a bit more about this crucial witness before I make a decision, and then I would discuss that with the other panel members. But usually, if you hear a remark to the effect that, well, I'm not really comfortable with carrying on because my most important witness isn't here. At that point, you can adjourn the hearing and reconvene it at a later date. And at that point, you point out to the accused person that, yes, we can reconvene the hearing, but you are suspended until you come back to the hearing. So there's no benefit to be gained if they do wish to reconvene the hearing. Personally, when I do hear an accused person make that statement, my most important witness isn't here, I am always ready at that point to adjourn the hearing. And the reason for that is, in particular where it's a serious case. What do I mean by serious? A long suspension, a big fine. In circumstances like that, I will discuss it with my two panel members, but I would certainly lean to adjourning, because if you carry on, and let's say you end up making a decision where somebody's given, say, a 3 or 6 month suspension, that person has probably got grounds for an appeal to the next governing organisation, because you carried on in the knowledge that that person's most important witness couldn't show up. Now, I have heard, some discipline panel members say, well, that's your responsibility to get them here. That's really not a good response. The hearing is intended, especially with serious cases. Yes, that person may be guilty, but if you're going to have the hearing, then do it properly and allow that person the opportunity to present their case. There very often are mitigating circumstances, even to more serious cases, and that is not a matter, if you like, of distrusting the game official, but sometimes the match reports or special incident reports don't always cover elements that might shift how a panel might view elements of the incident, and in particular, for example, softening their view of the charges. So those are, I think, two of the probably most likely circumstances where you would reconvene a hearing if it's actually begun. The other circumstance would be where an accused person receives a hearing notice and asks for a postponement. Now, that's not really sort of reconvening, but you can, if the discipline chair or the discipline coordinator feel that the reason for the postponement is a good one, most of the time you're going to allow the postponement, but you'll only want to allow one. And the one thing I think I would caution is you also want to be careful about the reasons for the postponement. I've had situations where coaches have tried to postpone hearings because they've got, in quotes, an important game. That's not a good reason. They also have to submit that request for a postponement 4 days, at least 4 days before the hearing. Same thing would apply with the game official, for example. I've had situations where I've required a game official to attend a hearing, and they have offered as a reason for not showing up the fact that they've got a game to run. Well, that's not a reason. If you accuse somebody of an offence where the misconduct is long enough that the discipline chair wants the game official there to make sure they get it right, then you've got to show up. I think that probably covers it. There may be other circumstances where you might want to reschedule, but I think the main consideration would be what's the purpose of the reschedule, and where possible look at it in an ethical way. There's no, let's put it this way, I think one of the things with the discipline process is that discipline panels are invested with a great deal of power. We don't want to abuse that power, and certainly we would much rather know that we provided the best opportunity possible for the accused person to present their defence, whether or not we agree with it or not.
Good.
And that's what most of us would want. So
Okay.
what's the next question?
So one final question. Is the secretary considered a panel member?
The secretary is considered a panel member if they are one of the 3 panel members introduced. You will find with some leagues they may have a discipline coordinator that sits in the hearing. That person is not a panel member, but a recording secretary is one of the panel members. So, for example, I have a couple of folks, when I know that I've got a more complex case, I have a couple of folks in particular who are terrific at taking notes and marking down important elements. So I would always try and include one of those people on the panel to be the recording secretary. But while they're making notes, they are still part of the panel. I'm asking that person if they have any, do they have any questions of the accused or the witness. They're not just there to take notes. They are there with the other 2 panel members to ask questions, to ascertain what information they need in order to come to a proper balanced decision, an informed decision, as best we can in those circumstances. Does that answer that?
That's great. Yeah. I think we're done. That's it for questions. One final comment. Ilya had asked about contacts at the OSA. So my guidance there would be to contact Sharon Tomasos, who's our coordinator. So she's our manager for administration for the OSA, but she's also a coordinator when it comes to working with Michael and the discipline and appeals committees that operate across the province. Sharon's contact details can be found on the OSA website under staff if you have any sort of additional questions or concerns. But as we finish this, thank you very much, Michael. That was fantastic.
Thank you.
Hopefully that's inspired a few more people to attend a workshop and learn even more about this, so they can get the information that they need to run an effective hearing in their districts.
Okay. Well, thanks very much, everybody.
Awesome. Thank you very much for your time, Michael. That was great. You go and get yourself a cup of tea or something a little stronger. And
I'm certainly going to do that.
Good man. Thank you very much, and take care, everybody.
All right. Good night.
Good night.